Hi, my name is SYAHEERA binti Nur Azam from Group 11.
Assalamualaikum, my name is AZFARIQAH with Faiz and I'm from Law299 Group 11.
Hi and Assalamualaikum. My name is FATIN binti Nordin. I'm from Law299 Group 30.
Hi, my name is SUZIANA binti Marzuki. My ID number 2019498316 and I'm from Group 13.
Implied terms can be divided into conditions and warranties. Condition is a stipulation that is essential to the main purpose of the contract. Breach of condition entitles the innocent party to repudiate the contract. Meanwhile, warranty is a stipulation that is collateral. The breach of warranty only entitles the innocent party to claim damages. Buyer shall have quiet possession of goods. It is a warranty and it is something minor. The buyer shall have and enjoy undisturbed possession of the goods. It means that when we purchase something, the third party will not come and claim the ownership of the goods. A breach will only entitle the buyer to claim damages. He cannot repudiate the contract.
Number 5, goods must be of merchantable quality. In Section 16(1)(b) SOGA 1957, where goods are bought by description from a seller who deals in goods of that description, there is an implied condition that the goods shall also be of a merchantable quality. What is a merchantable quality? Merchantable quality means that the goods sold must be fit for the particular use for which they were sold. It's general purpose of the goods. The goods sold must fit the purpose for which it is made or sold as set by the manufacturer. For example, the stove can be used for cooking. If the goods were unmerchantable, the seller would be liable for breach of implied condition, even though they are sold under the patent or trade name. But in Section 16(1)(b) does not apply where the buyer has examined the goods, and by such examination, the buyer would have discovered the defects ought to have been revealed. For example, if the buyer had been given opportunity to examine a jacket before he purchased it, he would discover the jacket has torn, but he still bought the jacket. Later, he cannot really claim the jacket is unmerchantable. Number 7 is implied condition in a sale by sample. Section 17 SOGA 1957. There are situations where a buyer buys goods based on the sample of goods given by the seller. Thus, in a contract of sale by sample, the goods sold must correspond with the sample. If the goods are bought in bulk, the bulk must correspond with the sample. If certain part of goods corresponds with the sample but the other parts are not, the buyer has the right to reject the whole bulk. Same situation if there is a latent defect rendering the goods unmerchantable, the buyer is also entitled to reject them.
Implied number 3, goods are unencumbered. According to Section 14, state there is an implied warranty that shall good be freedom from any charge or encumbered in favor of any third party not declared or known to the buyer before or at the time when the contract is made. When a seller sells goods to the buyer, it is his duty to ensure the goods are not subjected to any encumbrance. Encumbrances are financial impediment such as a tax, charge, or debit. If the seller does not inform the buyer of the encumbrance prior to sale, the seller is liable to breach of warranty and the buyer is entitled to damage. Next, implied number 4. Good must correspond with the description. Where there is a contract for sale of good by description, there is an implied condition that good shall correspond with the description. And if the sale by sample as well as by description, it's not sufficient that the bulk of the good correspond with the sample if the good do not also correspond with the description. Description can come from either the seller or the buyer. The buyer may want the good to be of the certain packaging requirement, or the buyer want the good to be of certain quantity, color, thickness, measurement. If the seller agree to supply the goods according to the buyer requirement at the time of making the contract, the seller must comply the implied condition. The allegation of sale under this provision is absolute, ineffective, whether the defect is small or inefficient. This condition also applies when the buyer is not seen the good but relying on the description alone, such as email order, sale of a catalog, or anything other from the description.
Implied condition as to fitness for particular purpose. A general rule, a buyer must be careful when making a purchase as only he knows the purpose of the goods he wants to purchase. The buyer is responsible in choosing quality goods which would fit his purpose in purchasing the goods. He is expected not to be careless or he will suffer the consequences of not being able to claim against the seller for the defects. This rule is known as caveat emptor, which means buyer must beware. In section 16(1)(a) provides that there is an implied condition that the goods must be reasonably fit for a particular purpose of the buyer. If the goods are not fit for the particular purpose of the buyer, the seller will be liable for breach of this condition and the buyer is entitled to rescind the contract and or claim for damages. However, if the buyer wants to sue the seller of breach of his implied condition, there are 4 conditions which must be fulfilled by the buyer, which are as follows. Number 1 is disclosure of purpose. The buyer must inform or disclose to the seller the particular purpose he requires the goods. As some goods may have some more than one purpose or functions, the buyer must inform the seller his purpose of buying the goods. He cannot blame the seller for supplying goods which do not meet his purpose if the goods can be used for the other purposes and the implied condition as to fitness for a particular purpose would not apply since he did not disclose his purpose to the seller. Number 2 is reliance on the seller's skill and judgment. The buyer must also establish that he had relied on the seller's skill and judgment before purchasing the goods. In other words, the buyer must have relied on the seller's recommendation as to which goods to buy. The degree of reliance is a matter of reasonable inference from the circumstances of each case. Number 3 is the goods supplied are of the description which the seller's business to supply. The goods bought by the buyer must be kind which is in the course of the seller's business to supply. And number 4 is the goods must not have been bought under patent or trade name. If a buyer bought the goods under a patent or trade name, it gives the impression that he is not relying on the seller's skill and judgment. He cannot later complain that the goods are not fit for the particular purpose he required. Lastly, implied term condition as to title. According to Section 48, there is an implied condition on the part of the seller that in the case of a sale he has the right to sell the goods, and that in the case of an agreement to sell he will have the right to sell the goods at the time when the property is to pass. This implied term requires the seller to have legal title over the goods to be sold to the buyer. If not, the buyer shall have the right to repudiate the contract since the seller is unable to transfer the title to the buyer. Apart from the repudiating the contract, the buyer may also recover the full price of the goods even though the goods have been used. The reason is because the buyer of the goods pays the price in order to obtain the ownership as well as to use the goods. Hence, if the seller does not have title of the goods, he will not be able to pass a good title to the buyer, which defeats the whole purpose of the contract.